Supplementary list, item number 1 for pronouncement of judgment.
So I'll read out only the operative portion or some part. One thing I have to say, in this case, it's the first time that I've come across a case where there are eyewitnesses to the accident, but conflicting.
Yes.
One said they also saw, the eyewitnesses means they saw with their own eyes how it happened.
And
The other said also they saw with their own eyes.
yes.
So whom to believe?
So that is true. That is true. But the contradiction which is found in the evidence of the insurance,
That is a different thing.
and they are taking different stand at different stages. That's the thing, you know. The question of the balancing.
I have analyzed the evidence on record, and finally this is my findings. Therefore, the fact that the driver of the Maruti car went and dashed against the stationary truck, resulting in the said accident, the same can only mean one thing, that there was contributory negligence on the part of the drivers of both the vehicles involved. This conclusion is arrived at by considering all possible scenarios of how the accident occurred and on the basis of preponderance of probability, as was pointed out in the case of Matthew Alexander. The percentage of contributory negligence according to this code should be shall be calculated at 50% each.
ज़्यादा हो गया.
Should be happy with that. So these are calculations as
Yes.
given.
Yes. And
In the final analysis, this court hereby sets aside and quashed the impugned judgment order dated so and so, and the claimant appellant is directed to be paid compensation for the amount of 37 lakhs 4,000 together with interest aforesaid. However, since there is contributory negligence of 50% on the part of the deceased husband of the appellant, therefore the respondent 3, New India Assurance Company Limited, is hereby directed to make payment of compensation to the appellant calculated at 50% of the said amount of 37 lakhs together with interest at the rate of 7% to be paid within 2 months from the date of this order.
and the interest is from the date of filing
From the date of filing of the
petition.
petition, yes. That has been
Clarified.
held here.
Right. Because interest component is for 11 years.
You will get whatever. If they don't go up, it's up to you. You get
Interest rate is 7%.
7%.
With this, they won't go. With this 50%, they will never go.
I don't know.
Highly obliged.
Nothing I can do. Except that, you see, the only thing that is, that's weighing upon this court is the fact that it's a social legislation. That's the only thing. The person has died.
Actual sufferers are family member.
You could have come under 163A.
5 lakhs only. 163, 5 lakh only. Not more than that.
Oh, yes. Thank you. Correcting TV.
May it please your Lordship. Lordship, I beg to mention item number 9. Your Lordship, it's a joint request.
Joint request, Your Lordship. Mr. Shulai is also on leave.
On plea made by the petitioner and the state respondent. Matter is adjourned. This is after 3 weeks.
Obliged, Your Lordship. Your Lordship, I beg to mention item number 2.
Participant for the petitioner, no objection. Lordship.
On plea made by Mr. Learned Counsel seeking accommodation. The petitioner not objecting to the same. Matter is adjourned. This is after 2 weeks.
Obliged, Your Lordship.
May it please Your Lordship, I beg to mention item number 3. Your Lordship, this is also a joint request.
Your Lordship, it's a joint request.
These are all matters 2022.
Your Lordship, Dr. Muzika is on leave and even Mr. Argurum.
Kindly let this matter come after 1 week, Your Lordship.
What is the matter about?
It's related to promotion.
Promotion.
Service matter.
It's a service matter, Your Lordship, with regards to promotion.
Okay. On plea made by Ms. seeking accommodation on the ground that the learned DSGI is indisposed. Matter is adjourned. This is after 1 week.
Any of that?
Your Lordship, similar prayer for item number 4. Your Lordship, is the other side as Sir Ha. I've already informed him.
You have sought his consent?
Yes.
I can do it. 2 weeks.
Much obliged.
May I please, Your Lordship? I beg to mention item number 7 and 8, my lord. It is a connected matter. My lord, it is a joint prayer for adjournment, my lord.
On plea made by the appellant by the parties, this is matter of 3 weeks.
My lord.
Supplementary list, item number 2.
Lordship, the
Matter settled.
it's settled, Lordship. The grievance of the petition has been addressed.
So nothing more is required.
Nothing.
Heard counsel for the parties. It is submitted that this matter has been referred for mediation, and on the process of mediation being completed, the mediator by communication dated 12/9/2025 has informed the Secretary, High Court Mediation Committee that the matter has been settled. Accordingly, nothing survives in this petition. That is disposed of.
Obliged, Your Lordship.
From daily list, item number 1.
On behalf of the petitioner, I have already made my submissions. Your Lordships recollect, this is that matter where
Okay, yes.
he was not considered for promotion in 2013.
You are seeking notional promotion now.
Yes, that matter. So it is for the state to reply now.
But have you cited any authorities, Mr.?
Yes, my lord. Two, I suppose.
Anyway,
Yes, my lord.
since you have concluded, Mr. Sen, you have started.
I've not started, my lord.
I will cite more judgments and rejoinder, my lord, on the points which my learned friend will be raising.
Yes.
May it please your lordship. My lord, in a nutshell, the petitioner's grievance is that in 2013, for the first time, he stood superseded from grade 3 to grade 2 by respondents 6 to 24, and there was a violation of one of the rules, the recruitment rules. And subsequently in 2015, yet again, the other respondents, that is 25 to 35, supersede the petitioner again in violation of these particular rules. Now, our contention in our affidavit was that, even assuming for a moment that there's been a violation of rules, whatever the case may be on merit, one has to come to court as early as possible, challenging inter se seniority or a promotion. Now, what your lordships will find that the first promotion that the petitioners aggrieve with happened on 10th of January 2013. The second promotion occurred on the 1st of June 2015. Now, if your lordships will kindly have para 12 and 13 of the writ petition at page 10.
Yes.
May I just read these pleadings, my lord.
Yes.
That the petitioner states that pursuant to the promotion of his juniors and being arbitrarily and discriminatorily superseded, the petitioner had made several requests to the department to look into the matter and to consider the petitioner's promotion in terms of his actual seniority as on 2013 and as per the seniority list of 1997. My lords will find there is no material particular with regard to when these requests were made, at which point and to which authority. This is just a bald statement. It doesn't seem to be correct. So fact does remain that even after the 2013 and the 2015 series of promotions, the petitioner did not raise his protest on this matter. Now, the only question that your lordships have to examine, apart from the question of delay in laches, whether there was acquiescence on the part of the petitioner. So I'll take your lordships further. Kindly have page 96. This is a letter dated 22nd of March 2016.
Yes.
May I read, my lord?
Yes.
Can you see the subject? Draft inter se seniority list of MAS officers.
Yes.
Madam sir, I am directed to enclose herewith the draft inter se seniority list of MAS officers and to request you to circulate the same to all officers under your control for their information and needful. Further, I am directed to inform you that any member of the MAS who stands aggrieved may submit his/her representation for consideration of the government within 30 days of the date of issue of this letter. Representation received after the aforesaid date will not be entertained and will be rejected summarily. So a draft inter se list, that is a gradation list, was prepared and circulated to the members of the department with the condition that in case they had any grievance with the list, they could raise a protest within 30 days, and thereafter any other protest which is lodged after the period of 30 days would not be considered and would be rejected. No protest was raised. There is no pleading to that effect that he has raised any kind of grievance with regard to the draft inter se seniority list, which subsequently was notified on 14/4/2016. So this is another very important aspect. Next, my lord, will see on 5/1/2017, the petitioner was promoted to grade 2 to the post of Assistant Director of Agriculture. He accepted this post without any demur, did not raise any protest even there. He thereafter wrote representations on 2nd of March 21 and 9th of August 2021, raising a concern with regard to the promotions that occurred in 2013 and 15 after a delay of roughly 8 years. So if he succeeds in setting aside the promotion of 2013 by having it declared invalid, the question is how far along has his representation come? There's a delay of 8 years, my lord. So this is the gist of our case, that there has been delay, laches, and there's been acquiescence on the part of the petitioner because he knew very well that a promotion had taken place, whether it was right or wrong. He ought to have challenged it within a reasonable period of time, but he allowed this to continue, allowed this particular process to continue. Now, without taking your lordship any further, I'll take your lordship to a few judgments on this point. The first is 1975 1 SEC 152. This is on the question of delay in challenge to a promotion order.
Yes.
Our contention in our affidavit is the same thing, that there has been a huge inordinate delay on the part of the petitioner in approaching this honorable court. And these are binding judgments of the Honorable Supreme Court on this specific issue. If your lordships will have para 2 at page 153. Let's have it.
Yes.
May I read, my lord? The main grievance of the appellant is that the second respondent, who was junior to him as assistant engineer, was promoted as divisional engineer in 1957 by relaxing the relevant rules regarding the length of service necessary for promotion as divisional engineer, and that his claim for a similar relaxation was not considered at that time. The learned judge of the Madras High Court, who heard the writ petition, was of the view that the relaxation of the rules in favor of the second respondent without considering the appellant's case was arbitrary. In view of the statement on behalf of the government that such relaxation was given only in the case of overseas scholars, which statement was not controverted, it is not possible to agree with the view of the learned judge. Be that as it may, if the appellant was aggrieved by it, he should have approached the court even in the year 1957 after the two representations made by him had failed to produce any result. One cannot sleep over the matter and come to court questioning that relaxation in the year 1971. That there is the further fact that even after respondents number 3 and 4 were promoted as divisional engineers over the head of the appellant, he did not come to the court questioning it. There was a third opportunity available to him to have come to court when respondents number 2 to 4 were again promoted as superintending engineers over the head of the appellant. After 14 long years, because of the tempting prospect of the chief engineership, he has come to court. In effect, he wants to unscramble a scrambled egg. It is very difficult for the government to consider whether any relaxation of the rules should have been in favor of the appellant in the year 1957. The conditions that were prevalent in 1957 cannot be reproduced now. In any cases, the government has decided as a matter of policy, as they were entitled to do, not to relax the rules in favor of any except overseas scholars. It will be wholly pointless to direct them to consider the appellant's case, but also respondents number 3 and 4, who are the appellant's juniors, because became divisional engineers in 1957, apparently on the ground that their merits deserved their promotion over the head of the appellant. He did not question it, nor did he question the promotion of his juniors as superintending engineers over his head. He could have come to the court on every one of these 3 occasions. Now, this is important, my lord. A person aggrieved by an order of promoting a junior over his head should approach the court at least within 6 months, or at the most a year of such promotion. It is not that there is any period of limitation for the courts to exercise their powers under Article 2 to 6, nor is it that there can never be a case where the courts cannot interfere in a matter after a passage of a certain length of time. But it would be a sound and wise exercise of discretion for the courts to refuse to exercise their extraordinary powers under Article 2 to 6 in the case of persons who do not approach it expeditiously for relief and who stand by and allow things to happen and then approach the court to put forward stale claims and to try and unsettle settled matters. The petitioner's petition should therefore have been dismissed in limine. Entertaining such petitions is a waste of time of the court. So a rough time period is sketched by the court for parties to come before the parties to put forward a challenge before a court. The next judgment again on this particular issue, where they've surveyed case laws relating to delay in challenging promotion orders. This is 2010 volume 12 SEC 471. I'll just apply a copy. I made a list, it's there. My lords will have page 480. Just check, there's a list of things for them. About 4 or 5 judgments. Hello, sir. Para 18, my lord, at page 480.
Yes.
The question of entertaining the petition disputing the long-standing seniority filed at a belated stage is no more res integra. A constitutional bench of this court and so considered the effect of delay in challenging the promotion and seniority list and held that any claim for seniority at a belated stage should be rejected inasmuch as it seeks to disturb the vested rights of any persons regarding seniority, rank and promotion which have accrued to them during the intervening period. A party should approach the court just after accrual of the cause of complaint. While deciding the said case, the court placed reliance upon its earlier judgments, particularly in so wherein it has been held that the principle on which the court proceeds in refusing relief to the petitioner on the ground of laches or delay is that the rights which have accrued to others by reasons of delay in filing the writ petition should not be allowed to be disturbed unless there is a reasonable explanation for the delay. In my humble submission, in this case, there is no explanation. No statements have been made adverting to that vacuum of that period. The court further observed as under, the party claiming fundamental rights must move the court before other rights come into existence. The actions of the court cannot harm innocent parties if their rights emerge by reason of delay on the part of the person moving the court. The court in so case also placed reliance upon its earlier judgment in the Constitution bench of so. It would be unjust to deprive the respondents of the rights which have accrued to them. Each person ought to be entitled to sit back and consider that his appointment and promotion effected a long time ago would not be set aside after a lapse of a number of years. Then kindly see the next page. They've reproduced a judgment. I'm referring to Placitum C, para 30 at page 481, my lord.
Yes.
And this is on the question of explanation for the delay. So it's not just about affecting third-party rights, but also purely a question of delay which ought to be explained. Yes. The petitioners have not furnished any valid explanation whatsoever for the inordinate delay on their part in approaching the court with the challenge against the seniority principles laid down in the government resolution of 1968. We would accordingly hold that the challenge raised by the petitioners against the seniority principles laid down in the government resolution of so ought to have been rejected by the High Court on the ground of delay and laches. Then please see the next one. The issue of challenging the seniority list, which continued to be in existence for a long time, was again considered in the court by this court in the case of so. Please see para 7, Placitum F.
Yes.
Satisfactory service conditions postulate that there should be no sense of uncertainty among the government servants created by writ petitions filed after several years, as in this case. It is essential that anyone who feels aggrieved by the seniority assigned to him should approach the court as early as possible, as otherwise, in addition to the creation of a sense of insecurity in the minds of the government servants, there would also be administrative complications and difficulties. So it's not just a question of affecting third-party rights, but the question of creating administrative complications and difficulties. And then please see the next page, Placitum B. The line beginning with raking up old matters. Let's have it.
Page 482.
Yes, 482, Placitum B. This is a part of para 9. The fourth last line from the bottom. Raking up old matters like seniority after a long time. Just next to Placitum B.
Yes, yes. Yes.
And this reads, raking up old matters like seniority after a long time is likely to result in administrative complications and difficulties. It would therefore appear to be in interest of smoothness and efficiency of service that such matters should be given a quietus after a lapse of some time. So again, not just on the issue of interfering with third-party rights or creating third-party rights or vesting third-party rights. This is on the question of administrative complications and difficulties. Then please see the next judgment at para 23. In B.S. Bajwa versus State of Punjab, this court, while deciding the similar issue, reiterated the same view, observing as under, it is well settled that in service matters the question of seniority should not be reopened in such situations after the lapse of a reasonable period, because it results in disturbing the settled position which is not justifiable. There was inordinate delay in the present case for making such a grievance. This alone was sufficient to decline interference under Article 226 and to reject the writ petition. Kindly see the word alone. Delay alone becomes a ground, not the other surrounding issues with regard to administrative complications or affecting third-party rights. Just the delay by itself is a ground to dismiss the matter. Then please see the next judgment. In Dayaram A. So-and-so versus State of Maharashtra, while reiterating the similar view, this court held that in absence of satisfactory explanation for inordinate delay of 8-9 years in questioning under Article 226 of the Constitution, the validity of the seniority and promotion assigned to other employees could not be entertained. In PS so-and-so, this is the judgment that I just referred to. The first judgment, they made a reference to this judgment at para 25. In PS so-and-so versus State of TN, this court considered the case where the petition was filed after a lapse of 14 years challenging the promotion. However, this court held that the aggrieved person must approach the court expeditiously for relief, and it is not permissible to put forward stale claims. The court observed as under, a person aggrieved by an order promoting a junior over his head should approach the court at least within 6 months, or at the most a year of such promotion. Then please see the next page. Para 28.
Yes.
In K. Abdul Majid versus State of Kerala, this court held that the seniority assigned to an employee could not be challenged after a lapse of 7 years. Please see, 7 years, Willard. In this case, it's 8 years. Could not be challenged after a lapse of 7 years on the ground that his initial appointment had been irregular. Even though on merit, it was found that seniority of the petitioner therein had correctly been fixed. It is a settled law that fence sitters cannot be allowed to raise the dispute or challenge the validity of orders after its conclusion. No party can claim the relief as a matter of right on the grounds for refusing relief is that the person approaching the court is guilty of delay and laches. The court exercising public law jurisdiction does not encourage agitation of stale claims where the rights of third parties crystallize in the interregnum. Then para 30, my lord will see. Thus, in view of the above, the settled legal proposition that emerges is that once the seniority has been fixed and it remains in existence for a reasonable period, any challenge to the same should not be entertained. In K.R. Mudgal, this court has laid down in crystal clear words that a seniority list which remains in existence for 3 to 4 years unchallenged should not be disturbed. Thus, 3 to 4 years is a reasonable period for challenging the seniority, and in case someone agitates the issue of seniority beyond this period, he has to explain the delay and laches in approaching the adjudicatory forum by furnishing satisfactory explanation. The first judgment that I was referring to, my lord, was from 1975, where they had fixed a period of 6 months to 1 year. Here that stands diluted up to 3 to 4 years. Then please see the last paragraph, para 31. The tribunal ought to have dismissed the case of so-and-so only on the ground of delay and laches as the applicant approached the tribunal at the verge of his retirement and after getting 2 promotions, while the other parties have got 3 promotions. In the said case, the private respondents have not considered it proper to contest the case because both of them were likely to superannuate just thereafter on attaining the age of retirement. So even here they hold there's no need to go into the merits of the case. Once there is a case, once it appears to be a case of gross negligence on the part of the petitioner and there's inordinate delay, it should be dismissed on the ground of delay alone. The third judgment, my lord, this is on the question of acquiescence, delay and laches. And on the basis of this, lordships will consider from the petitioner's pleadings whether there has been acquiescence on his part. Delay and laches is quite clear, but acquiescence is another important aspect which has to be examined from his own pleadings. Now we'll turn to page 427. Once again, in this judgment, the court refers to several judgments on the same proposition. If your lordships will have para 29, they have reproduced several passages from different judgments. If your lordships have that, page 427, para 29.
Yes.
Union of India versus N. Murugasan, delay, laches and acquiescence. The principles governing delay, laches and acquiescence are overlapping and interconnected on many occasions. However, they have their distinct characters and distinct elements. One can say that delay is the genus to which laches and acquiescence are species. Similarly, laches might be called a genus to a species by the name of acquiescence. However, there may be a case where acquiescence is involved but not laches. These principles are common law principles, and perhaps one could identify that these principles find place in various statutes which restrict the period of limitation and create non-consideration of condonation in certain circumstances. They are bound to be applied by way of practice requiring prudence of the court than of a strict application of law. The underlying principle governing these concepts would be one of estoppel. The question of prejudice is also an important issue to be taken note of by the court. Laches. The word laches is derived from the French language meaning so-and-so, reminiscence and slackness. It thus involves unreasonable delay or negligence in pursuing a claim involving an equitable relief while causing prejudice to the other party. It is neglect on the part of a party to do an act which law requires while asserting a right, and therefore must stand in the way of the party getting relief or remedy. Two essential factors to be seen are the length of the delay and the nature of the acts done during the interval. Now, this is very important. The length of the delay and the nature of the acts of the petitioner. As stated, it would also involve acquiescence on the part of the party approaching the court apart from the change in possession in the interregnum. Therefore, it would be unjustifiable for a court of equity to confer a remedy on a party who knocks on its doors when his acts would indicate a waiver of such a right. By this conduct, he has put the other party in a particular position, and therefore it would be unreasonable to facilitate a challenge before the court. Thus, a man responsible for his conduct on equity is not expected to be allowed to avail a remedy. A defense of laches cannot be allowed where there is no statutory bar. The question as to whether there exists a clear case of laches on the part of a person seeking a remedy is one of fact, and so also that of prejudice. The said principle may not have any application when the existence of fraud is pleaded and proved by the other side. To determine the difference between the concept of laches and acquiescence is that in a case involving mere laches, the principle of estoppel would apply to all the defenses that are available to a party. Therefore, a defendant can succeed on the various grounds raised by a plaintiff, while an issue concerned alone would be amenable to acquiescence. We have already discussed the relationship between acquiescence on the one hand and delay and laches on the other. Acquiescence would mean a tacit and passive acceptance. It is implied and reluctant consent to an act. In other words, such an action would qualify a passive assent. Thus, when an acquiescence takes place, it presupposes knowledge. Please note this, my lord. It presupposes knowledge against a particular act. From the knowledge comes passive acceptance. Therefore, instead of taking any action against any alleged refusal to perform the original contract, despite adequate knowledge of its terms, and instead being allowed to continue by consciously ignoring it and thereafter proceeding further, acquiescence does take place. As a consequence, it reintroduces a new implied agreement between the parties. Once such a situation arises, it is not open to the party that acquiesced itself to insist upon the compliance of the original terms. Hence, what is essential is the conduct of the parties. We only dealt with the distinction involving a mere acquiescence. When acquiescence is followed by delay, it may become laches. Here again, we are inclined to hold that the concept of acquiescence is to be seen on a case-to-case basis. And the last paragraph, para 30, just two more paragraphs. SBI versus MJ James. What is a reasonable time is not to be put in a straitjacket formula or judicially codified in the form of days, etc., as it depends upon the facts and circumstances of each case. A right not exercised for a long time is non-existent. Doctrine of delay and laches as well as acquiescence are applied to non-suit the litigants who approach the court appellate authorities belatedly without any justifiable explanation for bringing action after unreasonable delay. And then your lordship kindly turn to page 431, last two paragraphs. My lord has it?
Yes.
Para 39, my lord. Before proceeding further, it is important to clarify a distinction between acquiescence and delay and laches. Doctrine of acquiescence is an equitable doctrine that applies when a party having a right stands by and sees another dealing in a matter inconsistent with that right while the act is in progress and after violation is completed, which conduct reflects his assent or accord. He cannot afterwards complain. In literal sense, the term acquiescence means silent assent, tacit consent, concurrence or acceptance, which denotes conduct that is evidence of an intention of a party to abandon an equitable right, and also to denote conduct from which another party will be justified in interfering such intention. And then please see the next paragraph 40. Latches, unlike limitation, is flexible. However, both limitation and latches destroy the remedy but not the right. Latches, like acquiescence, is based upon equitable considerations, but latches, unlike acquiescence, imports even simple passivity. On the other hand, acquiescence implies active assent and is based upon the rule of estoppel in pace. As a form of estoppel, it bars a party afterwards from complaining of the violation of the right. Even indirect acquiescence implies almost active consent, which is not to be inferred by mere silence or inaction, which is involved in latches. Acquiescence in the manner is quite distinct from delay. Acquiescence virtually destroys the right of the person. Given the aforesaid legal position, inactive acquiescence on the part of the respondent can be inferred till the filing of the appeal and not for the period post filing of the appeal. Nevertheless, the acquiescence, being in the nature of estoppel, bars the respondent from claiming violation of the rights of fair representation. The other position, my lord, because lordships may be tempted to still interfere by saying we'll ignore the question of delay and look into the violation of the particular rule. On that point, my lord.
Now, has that delay been explained?
No, I can take your lordships through the. I will take your lordships momentarily through the facts of the case. From what I understand, please have page 10 of the writ petition, my lord, first. Only for lordships to notice what the pleadings are and whether delay has been explained. Now, para 11, they've made a reference to the second promotion order of 2015, where the other respondents, that is respondent number 25 to 35, superseded the petitioner. So that is referred to in para 11. Para 12, they say they made several requests to the department complaining of this, but there is no material particular with regard to that. No representations have been enclosed. Then please see para 13, that the petitioner states that the state respondents did not consider the request of the petitioner for promotion. And the question is, where was the request? When was it made? Where are these documents? Where are the representations? However, the Government of Meghalaya Director of Agriculture by notification number so-and-so 2016 had prepared and notified a new seniority list of 2016 of the Meghalaya Agricultural Services officers. That the new seniority list 2016 has placed the respondent numbers 6 to 35 within a separate interstate seniority list of the Meghalaya Agricultural Services Grade 2 officers, whereas the petitioner, who was previously placed at a higher position to the respondents number 6 to 35 in the seniority list 1997, has been placed in a separate list of Meghalaya Agricultural Services and so on. Then please see the next page. Again, they refer to the notification of the interstate seniority list of 2017. As your lordships proceed, my lords will find at para 15 that the petitioner states that upon the belated promotion, the petitioner is now being placed before the respondents number 6 to 35 who had arbitrarily superseded him during 2013 and 2015 in the seniority list, and that at present some of the juniors of the petitioner have been promoted and reached the level of senior grade in grade 1, and whereas the petitioner is still lingering at the grade level 2. That the petitioner being aggrieved by his belated promotion and being arbitrarily and discriminatorily superseded without giving any reasons thereof, the petitioner has made several representations dated 21. Now that vacuum from 2013, 2015 up to 21 is not explained, except the bald statement that he did make representations without any material particulars of that. And even thereafter, lordships find there is no explanation for this inordinate delay. So that entire vacuum of that period has not been explained. The judgment that I was referring to, my lord, is with regard to a void order. Now, what is the effect of a void order? On the face of it, lordships find that this order is absolutely illegal and invalid, untenable. Again, your lordships will have to examine the delay. Merely because an order is void does not mean the courts have to jump in and be tempted to interfere. Please see para 10 at page 453, the last page, my lord.
Yes.
Did you find the judgment? Well, let's have it.
Yes.
The order or action, if ultra vires the power, becomes void and it does not confer any right, but the action need not necessarily be set at naught in all events. though the order may be void if the party does not approach the court within reasonable time, which is always a question of fact, and have the order invalidated or acquiesced or waived, the discretion of the court has to be exercised in a reasonable manner. When the discretion has been conferred on the court may in appropriate case decline to grant the relief even if it holds that the order was void. The net result is that extraordinary jurisdiction of the court may not be exercised in such circumstances. So again, irrespective of the fact that on the face of it, palpably the order appears to be void, it does not mean the courts have to interfere and set it aside. Delay, conduct, acquiescence, latches, all of that has to be examined. Yes. Then there was the other issue that even assuming if Lordships ignored the question of delay and latches, what would be the effect of this period? And Lordships decide to interfere with this promotion order of 2013 and 15. Would the petitioner be entitled to any kind of relief? What would be the relief? One is notional promotion, and consequentially whether it be entitled to any kind of monetary relief. That's on that point.
See, Mr. Sir, if suppose, I'm not saying so, if notional promotion is is conferred or given to him, that would not upset the the situation as it is now.
As on today? Depends, my lord. But what my friend is now asking for, from what I understand on the last date, he's saying he's not insisting on any kind of back wages, the arrears. He's not insisting, but he wants some sort of a restructuring of his pension. Now, from what I understand, he was promoted thereafter to grade 1 as well. He was eventually promoted to grade 1. So his last drawn pay is that of an officer from grade 1.
Okay.
Promotion is going to be determined on the basis of that. Whether he has served from 2013 up to 21 in grade 3 or 2 will be inconsequential. That is my understanding. These are the instructions that I have. The question of his pension will be decided on his last drawn pay. His last drawn pay is that of grade 1. So he is receiving pension on the basis of that. Now, even assuming he is given his last drawn pay from 2013, which will be subject to all these cases, I don't think that really affects his pension. It does not amount to any restructuring except the question of serving and getting the benefits for whatever number of years he has, the increments.
He is not insisting on that.
He is not insisting. So if he is not entitled to back wages on the basis of this no work, no pay principle, he is also not entitled to increments. So on the day he retired from grade 1. So therefore his pension has now been structured on the basis of his last pay. So there can't be any change at all, according to me. And it's a dangerous path to tread on, in my humble submission, because there are no pleadings. We've not had a defense in this matter. It's a completely different cause of action.
Okay.
Completely different cause of action. Lordship says there's no pleading. On what basis will your Lordships proceed to grant that relief? Especially with regard to restructuring of the pension, if at all. There must be some pleadings before Lordship. I really don't know. I can't address that point in this manner.
I think I've made a query to Mr. Nongri.
My lord.
As to whether he has to amend the petition or the prayer. I think nothing has been done, Mr. Nongri.
Not required, my lord. Your Lordships will mold the relief accordingly, my lord.
But what he says so is that he has been taken by surprise as far as your.
My lord, these are legal points, not factual points. If I am given a notional promotion and I'm not pressing for back wages, my lord, then my notional promotion will be counted from the date when my junior was promoted, and my pay will be fixed accordingly, my lord. Whatever is increments are entitled to me at that point in time, that will have to be given to me, so that on the day of my retirement,
that will increase substantially.
Yes, my lord. On the day of my retirement, I'm not asking for back wages, and neither is anyone being my lord, disturbed, since everyone is retired. So that is the simple thing. Let him complete.
May I just explain why this is again a dangerous proposition? The first promotion of 2013 was from grade 3 to grade 2. These people, that is respondent number 6 to 24, did not supersede him to grade 1. They superseded him to grade 2. Similarly, in 2015, the other respondents, the remaining respondents 25 to 35, superseded the petition from grade 3 to grade 2. At which point did they come to grade 1 has not been explained in the writ petition anywhere. That is not the subject matter of challenge. My lords, please see the prayer. So which is why molding of relief at this point on this particular issue of restructuring the pension is a somewhat difficult proposition, my lord. I understand the anxiety of the petitioner, but I think this is a completely separate cause of action. Please see the prayer at page 13. In the premises aforesaid, it is prayed that your lordships may be pleased to call for record, issue a rule calling upon the respondent to show cause as to why a writ in the nature of mandamus should not be issued directing the respondent to restore the petitioner to the level of actual seniority as on 2013. To what? Grade 2. Does not refer to grade 1. When did they join grade 1? Has not been explained anywhere. Please see the seniority list of 2013. They're all to grade 2, not to grade 1. So that's what I'm saying. From assuming for a moment, lordships hold that in fact there was no illegality and he was actually appointed to grade 2 along with his peers in 2013. That point of the original point of time. He was still appointed to grade 1 only in 2021. There has been no challenge to his peers' promotion to grade 1. That is not mentioned anywhere. So how does your lordship decide when should it be? His last date, his pension has been decided on the basis of his last pay drawn. That is in 2021 in grade 1 post, not grade 2. That is completely immaterial and inconsequential to this writ petition. So lordship will just see this judgment that I am referring to. This is on the no work, no pay principle.
Before my learned friend proceeds, as far as the fixation of pay and increment is concerned, your lordships is not going to issue a mandamus. Your lordship is only going to issue a direction to them to consider my case, my lord. They will have to do the exercise. Your lordships is not going to do the exercise. I'll show a judgment to that effect, my lord.
So, okay. So now you see what happened is the ball will be in the court again.
Yes, my lord. Your lordships will grant me
whether such a prayer will be considered or not, that becomes...
Yes, my lord.
So again...
Then the cause of action will arise, my lord.
Okay.
Your lordships is not going to direct that he should get so and so pay. Your lordships will only direct them to consider my case for notional promotion with effect from the date for this and this reason, my lord. That's it. And consider what I'm entitled to.
Let him finish.
Yes.
So I think today my friend is making a different submission. On the last occasion, what I recall very specifically, my friend had said he wants this relief to be granted. There should be a molding of the relief. One, that a deemed date should be decided of 2013 and he should be granted notional promotion. He gives up his claim for arrears of pay. That was the second issue. And the third was there should be a restructuring of his pension. That is what he sought from this court. I needed some instruction on this whole question of restructuring of the pension. Now what I've come back with is this. Even for your lordships to interfere with this matter and grant notional promotion, he has to cross the hurdle laid down by these judgments. That is the question of delay. These are obvious hurdles. It has not been explained in the writ petition. If he cannot cross these hurdles, the question of granting notional promotion by deciding a deemed date of 2013 does not arise. He must have to overcome all these hurdles first. Then the question of granting that relief of notional promotion and molding of the relief will arise. And rightly said, the question of any consequential benefit, whether he is entitled, he is giving up the question of arrears of pay. That's one thing on the basis of this no work, no pay principle. If that is the case, then the next question is whether he is entitled to any restructuring of pay. I am saying it is not necessary for your lordships to go into that. He may make a representation and that's only provided if your lordships grant this relief. So that's a completely different chapter. First, we must deal with the question of grant of relief in the first phase, whether he is entitled at all, in view of the obvious delay. That's the first aspect. So if your lordships decide to grant notional promotion with effect from 2013, that will only cover grade 2. His last drawn pay will be on the basis of grade 1, which he got in 2021. There is no challenge to that. Nothing at all. So I'll just complete my submission on this point, Willard.
He was promoted from grade 3 to grade 2.
And then subsequently...
2017.
When? 2017.
17. And to grade 1 in 21. 21.
Okay.
This judgment, Willard, this is State of Haryana versus OP Gupta, 1996, 7 SEC 533. 533. Although my friend has already abandoned this particular argument, still I just wanted your lordships to have a look at this judgment. Why and in what circumstances this principle applies and what are the exceptions to this principle. My lords will have page 535, para 7.
Yes.
This court in so-and-so versus Union of India considered the direction issued by the High Court and upheld that there has to be no pay for no work. That is, a person will not be entitled to any pay and allowances during the period for which he did not perform the duties of a higher post. Although, after due consideration, he was given a proper place in the gradation list, having been deemed to be promoted to the higher post with effect from the date of his junior was promoted. He will be entitled only to step up the scale of pay retrospectively from the deemed date, but he is not entitled to the payment of arrears of the salary. The same ratio was reiterated in so and so. It is true as a point, as pointed out by Sri Huda, that in Union of India versus so and so, this court has held that where the incumbent was willing to work but was denied the opportunity to work for no fault of his. Now, these are the circumstances which are the exceptions to the rule. It is true as pointed out by Sri Huda in the case of so and so. This court had held that where the incumbent was willing to work but was denied the opportunity to work for no fault of his, he is entitled to the payment of arrears of salary. That is a case where the respondent was kept under suspension during departmental inquiry and sealed cover procedure was adopted because of the pendency of the criminal case. Where the criminal case ended in his favor, departmental proceedings were held to be invalid. This court held that he was entitled to arrears of salary. These are the only exceptions to the no work, no pay principle. That is not the case here. He has never worked in a higher post, he has never shouldered higher responsibilities. And it is not a case that he was prevented from doing so. He has acquiesced to the situation. 2013 and 2015, whatever promotions took place, gradation lists were prepared, draft matters were prepared, he never raised a challenge, he accepted it as is. 8 years passed. And only after he got the grade 2 and grade 1 promotions did he decide to come before this honorable court. And please see the next paragraph.
Yes.
The next line, my lord. That ratio has no application to the case where the claims for promotion are to be considered in accordance with the rules and the promotions are to be made pursuant thereto. Only in a case of a DP, where a person has been prevented, he's been placed under suspension and the DP has been subsequently held to be invalid. Please see the next paragraph. In these appeals, unless the seniority list is prepared and finalized and promotions are made in accordance with the rules on the basis of the above seniority list, the question of entitlement to work in the promotional post does not arise. Consequently, the payment of arrears of salary does not arise, since admittedly the respondents had not worked during that period. The High Court was therefore wholly illegal in directing payment of arrears of salary. The order of the High Court accordingly is quashed. So whatever changes to the pay scale etc. will happen only if he succeeds in explaining the delay, and Lordships admit that delay is not required. It has been satisfactorily explained. We will not go into this issue. Lordships also hold that there has been no latches on his part, and Lordships hold that from his conduct there has not been any acquiescence. In that situation, Lordships may say that we will declare that this particular promotion is invalid and thereafter grant him notional promotion, and then to examine whether he is entitled to any sort of restructuring pay or any arrears, etc. And last judgment, Willard. This is 2007-15 SCC 777. State of Haryana versus SK Khosla.
Yes.
Please see para 2. This is a short judgment, 2 paragraphs. My lords may lead it allegedly. I'll just refer to para 2. Heard the learned counsel for the appellants. He brought to our notice a decision of this court in State of Haryana versus OP Gupta. That's the last decision that I read. Whereunder, in respect of an identical matter arising out of similar proceedings of even date, this court, while setting aside the decision of the High Court, allowed the appeal at the instance of the state and held that in the circumstances noticed in that case, which are identical as well as the cases before us, the question of payment of arrears of salary with retrospective effect from the notional dates does not arise, since indisputably the respondents had never worked during the period in the promotional post, the settled principle in such case being no work, no pay. The said principle applies for equal force to the applies with equal force to the cases before us too, applying the ratio to the said decisions. These appeals are also allowed and the order of the High Court are set aside. So they reiterate the position laid down by OP Gupta and hold that if a person has not served in a post, has not shouldered those responsibilities, the question of granting that relief does not arise. So in a nutshell, minutes, to sum it up, there is gross delay, unexplained, inordinate delay of 8 years in approaching this honorable court, and the multiple judgments that are placed, of the thousands of judgments that there are, that court need not go into the merits. If there is inordinate delay, dismiss matter right there. The question of the going into the merits does not arise at all. So I'll reserve some time if my friend replies today. I apologize, I could not. I made a set of copies for my friend. I'll just try and take out another set for these judgments that I'm referring to.
Necessarily, he has to, if you want to respond to those judgment, then he has to.
The Manoj may have it on Monday.
On Friday,
Monday's coming?
Friday, my lord. Friday is a little here. He won't be here.
Monday.
Tuesday then, my lord.
Fine.
Just the question of that pay scale, my lord. My learned friend just read a judgment. He handed over a copy to me, 1996. In that very judgment which he just read just now.
O.P. Gupta.
In O.P. Gupta, my lord. O.P. Gupta. My lord, the para 7 itself, it says that he will not be entitled to my lord, back wages. But it says, my lord, he will be entitled only to step up the scale of pay retrospectively. That is all I'm asking for, my lord. The scale of pay.
I understand that. That's what he said the last time. That has to be examined on the facts. Whether he's entitled, where has he served, what is his last drawn pay. These are matters which have not been dealt with in this writ petition. This is a completely new cause of action. I'm not saying he's not entitled.
I'll reply on Tuesday, my lord.
That's all.
I'll come back on it.
And again, this will only be possible if he crosses the hurdle of delay. That's the other issue.
Heard Mr. S.N. Leonard G.A. for the state respondent. The hearing in this matter will continue on the next date as prayed for by the parties.
On Tuesday, my lord.
23rd.
List this matter on 23rd.
We'll conclude, my lord, 23rd. Yes.
Hopefully.
My lord, should we come with our notes ready, my lord?
It's up to you. You can do that, or you can do it leisurely at the end of, when everything is said and done.
No, I'll also have to hear what my friend says. Obliged, my lord.
Compilation you can bring at any time.
Yes.
Item number 5.
Lord, this matter may kindly have it next week, Lord. We have some other matters as well. I think my learned senior is also engaged in a different matter.
Your Lordship, just a small prayer, my Lord. If my Lordships allow us to file an affidavit, bring on record some orders. Mr. Lordships, I'd like to pray, my Lord, to file an affidavit, bring on record some orders passed by the Honorable Court, my Lord. When observation has been made that the execution, yes, by the then...
Those orders are already before your Lordship.
In this court,
My Lord.
in this case.
Not this, my Lord, by the then Chief Justice, my Lord.
No, if there is an orders, affidavit is not required. They can produce the order. I will not contest it. The orders of the court.
Orders of the court.
I will not contest that. Affidavit is not necessary.
You just compile it and then...
Yes, because I'm making a similar compilation for all the orders of the court.
Okay. On pray made by parties, this is matter of 1 week.
Lordship. Highly blessed.
Item number 6.
You're for the petitioner?
Yes, Your Lordship. I will stricten the petition, Your Lordship.
Yes, please start.
So, Your Lordship, here in my petition, this I've challenged the order dated 9/12/2024. In my review petition, and I filed this petition for continuation of delay for
So this court is hearing only on the
Condonation delay.
on the application for
Only
condonation.
condonation delay. Not the main relation. So, you'll see when I file this petition along with the condonation delay, and petitions come for this consideration condonation delay, the opposite party number 2 has filed the affidavit in opposition and challenge this one, giving lots of queries thereof. So first of all, you will say, as because long time hearing took place earlier, then this matter has come up again. Now in this petition, I have specifically mentioned here, you will see, if I go in paragraph 4, you will see,
yes,
that's page number 5. I have taken a specific plea that the humble petitioner begged to state that the civil revision petition was to file within a period of 90 days following the date of order, and the same should be filed within 90 days, that is within 8/3/2025. So if I consider, I have given it this, if I consider this, I have to file the civil revision petition within 90 days, then it should be 8/3/2025 and without calculating the period of limitation.
yes.
So you will see I filed later on. That's why this without calculating period to obtain the certificate, the order, and if the period is 70 days required to obtain the certificate copy of the order dated 9/12/2020 is exempted in the civil revision petition file, the humble petitioner is within the time. So I state here in this explanation, you will see that I know this I have to file within 90 days and I should have been filed on 8/3/2025, but obtaining this certificate it is taken 72 days. So considering these 72 days, then I am within the time. So now question is why I filed this petition. So if I didn't file this petition and if I didn't explain to the court, then it is time barred for 18 days. So this is the case here. I filed a petition if I consider this period for obtaining the certificate, then within the time there is no delay. But if I consider from the date, then there is a delay. So this is my petition basically, my condonation petition. Nothing more than this. And for this particular purpose, paragraph 3 I have given when I have applied and when I got it. So this is my petition. So this here. Then another aspect of message here, receive here in this case. Then paragraph 5 given that the humble petition begs to state that his elder brother Sri Antus Kharsati expired on 1/3/2025 and family beban and humble petitioner could not file this civil petition within the time, and the time required for filing the civil petition by the petitioner. Then paragraph 6 you will see.
Yes.
That the humble petitioner could file the petition on 18/3/2018, but the petition returned for certain defects and needed corrections, and filing a fresh and petition could be filed only on the date presented in the court caused delay 18 days without considering the period of required to obtain the certificate copy of the order dated 9/12/2024. So what's happening on 18th could file, it is presented to the registry, and they say this, no, this you have to give this petition for condonation delay also because it may be affected.
But that period will not be counted.
So
see that period where the registry has directed you to make some correction.
So you will see this matters we have even included this one also.
Okay.
just we mentioned here this we came to the court and after that this happened, but we didn't give out this is the happen and after that we have rectified. So this is the petition and after that in the prayer we have given. It is therefore prayed that the Senate routine can receive please to condone the 18 days delay for filing the civil division petition by the humble petitioner against the order dated 9/12/2024 and passed therein. So I am confirming this 9/12/2024, the order passed by this special judicial officer. Now my specific prayer is there only for 9/12/2024.
Okay.
So you will see here this our opposite party number 2 has raised lots of objections here regarding this and going back to this merit of the case and others. So in this respect the matters you will see I beg to just refer this some judgments you will see before this on court. Let's see it will be if I what do you say regarding this matters you will see I just make some short synopsis here. It is I can give it a little better you will see this. I can give the copy just I'll be making this submission on this basis of it. Just you can just take this position. So you will see this already I have just made the submission. So I just referred this it is given in my synopsis I have given here. You will see that the petitioner filed a petition for condonation delay for filing this civil petition before this honorable court against the order the line trial court dated 9/12/2002. Already I mentioned you will see. On considering the date of order, there are 18 days delay. However, on considering the date of petitioner filed a petition for certificate copy on 10/12/2024 and obtained the certificate on 19/2025 after 72 days of the application for certificate copy and the petition filed revision on 24/3/2025. The civil petition, the petitioner is within the stipulated period of limitation. So whole submission and paragraph I shown. This is the short submission of mine. That this is that we are within the time. So here you will see if you take consideration of this section 12(2) of the Limitation Act, I will not be burdening this could just as the mentioning. Then also we are within the time within provision of law, and then even if we consider the Article 131, then within 90 days, then also I am within the time. So now you will see. Now this situations come up when we file this petition and condonation delay was coming to here, and then opposite party number 2 has raised the objection and filed this affidavit of opposition, giving the merit of the case, all this merit of the case. So here in this petition you will see I am not in the merit of the petition because of it my condonation delay petition to be either to be admitted or not. So this is the petition here you will see. So in this respect the matters you will see when the affidavit filed, I didn't file any reply on the basis of the or additional affidavit to that extent. So I'll be deciding on the legal points you will see.
Okay.
Whether this affidavit filed and merit of the petition to be heard at that stage, whether it is correct or not. And what is the merit? If this subsequently court finds that there is no merit of the case, all right. But now I am coming only on the petition. I filed a civil petition against the order of the special judicial officer, and I am saying in one sense it is within the time, and another aspect I am saying this is not within the time, it is some delay. So this aspect of the matters will be considered by the court, whether I have sufficiently explained this my delay and whatsoever this points thereof in my petition which is correct or not. So here, Lucy,
Yes.
I'll be referring this first of all, this one, as I'll be making the gist of it. That's 2025 SCC. This online SC 54.
Yes.
Para 16, Lucy. Make it a whole paragraph.
Yes.
Latter part is most important. The length of the delay is definitely a relevant matter which the court must take into consideration while considering the delay, whether delay should be condoned or not. From the tenets of the approach of this respondent therein, it appeared that they want to fix their own period of limitation for the purpose of institution of the proceeding for which law has prescribed a period of limitation. Once it is held that the party has lost his right to have the matter considered on the merit because of his own inactions or long, it cannot be presumed to be a non-deliberate delay, and in such circumstances the case that he cannot be heard it, and then substantial justice deserves to be referred as against the technical consideration. While considering the plea of condonation delay, the court must not start with the merit of the case. Min matters. So it is given in this when this condonation delay will be coming up, then merit of the case will not be coming up the matters. The courts wish the duty to first to ascertain the bona fides of the explanation offered by the party seeking condonation. It is only if the sufficient cause assigned by the litigant and oppositions to the matters are said, the equally balanced that the court must bring into the aid of the merit of the matters of the purpose of the condonation of delay. In another sentence, 2025, Volume 1, SCC 625.
6.
2025, Volume 1, page 625.
625.
The paragraph 22.
Yes.
This court in Commissioner versus Labour Commissions taken in view the while the deciding an application for condonation delay, the High Court would not have to gone into the merit of the case. It has been further held in SCC 526 para 5. That's while deciding on application for condonation delay, it is well settled that the High Court should not have gone to the merit of the case, and it should have only seen whether sufficient cause has been shown by the applicant for condonation delay for filing this appeal before it. We ourselves have also examined the application filed under Section 5 of the Limitation Act before this High Court, and in our opinion, the delay of 170 days has been properly explained by the applicant That being the position, we set aside the impugned order of the High Court, and consequently appeal filed before the High Court is restored to the original file, and the High Court is requested to decide the appeal on merit in accordance with the law after hearing the parties and after passing the reasonable order. So in this also we received 2025, in this Supreme Court decided that when this condemnation delay has come before the National Court, then condemnation delay petition to be heard first and then to go for the merit, Your Lordship. So I am here on this petition, Your Lordship, this only for the condemnation delay. So whether it will be considered or not, so not the merit of the case. So what's the objection filed by the opposite party for the merit of the case, and including all? So this is not sustainable. So this is my first submission, Your Lordship. And secondly, Your Lordship, here that's considering this aspect of this matters, this I filed the petition. Now that what has prompted me to file the application for condemnation delay? For this particular purpose, so I am having some citations. So this is the legal points, because basically.
What, Mr. Devnath, in your petition for condemnation of delay, have you cited your grounds?
Yes, Your Lordship.
Sufficient cause.
Sufficient cause I have given you.
See, one thing you said that the petition was filed within time, if that 72 days is taken into account. But if, see, since you have filed application for condemnation of delay, what are your grounds or your?
So Your Lordship, I have just mentioned in the paragraph, but not as a ground, but I have mentioned in my sequences paragraphs, not as a ground.
No, why, what is the cause for your delay?
So here my cause is there, Your Lordship. First of all, I have given that's first of all I have taken the certificate. It is taken 72 days.
Okay.
Then secondly, I came this, Your Lordship. After this, I came before the after this was happened. In between, my brother has expired, who is one of the petitioner. So that time also I have taken this again paragraph 5. He was one of the petitioner in this case. That the humble petitioner begged to state that his elder brother.
Okay.
He expired on 3/2025. So if I have taken this one, even it was, then it was not possible due to some matters. And after this, I say you received this. I came before the Honorable Court on 18/3, and after this, it was returned for technical defect. So again, I have to change my petition, and then came. So considering all this aspect, but I am not saying that this is the matter I given. I am having this I have given, but I have been inclusive because these are the matter not to be brought before this Honorable Court. So this is in between court and myself. So I have given this. I came on 18. And after this again some problems come, and then after this again it is prompted to me to change. So when some changes, their petitioner to call.
That will not be considered.
So I am not blaming to anybody else. Just I came before this court, and it was the registry, and after this there was some technical defects, and then after this it is taken sufficient time because to correct and petitioner to come and sign the paper. So I am not giving all this, but I have given this sufficient cause reason. And after giving this one, if you saying this, if I consider this 72 days. Then only for 18 days coming, so it is within the time. But still, I have given this condemnation petition. This is my, and in this respect, the matters you will see this our Supreme Court as well as this High Court of Guwahati High Court full bench also there. That if the delay is there, then I can file the petition. There is no harm. Though protection is given in 12 section 12 to even article 131, but it is not prevented to me to file this application. It is proper explanation that I can file this application and giving this. So these are those, Your Lordship, I am having this. Just 1 minute. This one.
Yes, what's this?
This is your lordship regarding this filing of the condemnation delay petition. It is in 1976, volume 4, SCC 464. And para 13 will be
Para 13.
para 13. So, in the case of State of Uttar Pradesh versus Maharaj Naren, the appellants obtained the 3 copies of the order appeal against by the applying on the 3 different dates for the copy. The appellant filed along with this memorandum of appeal that copy which has taken maximum time for the preparation of and sought to exclude the maximum time in the competition the period of the limitation of filing appeal. The court, while holding this appeal to be within the time, observed that expressions time required in section 12(2) of the Limitation Act cannot be understood as the time absolutely necessary for obtaining the copy of the order, that what is deductible under section 12(2) is not the maximum time within the copy of the order appeal against would have been obtained. If that be the position of law in case where there was no allegations of the loss of any copy or a fortifying it, or would follow that where as the case prevalent as the case present case the copy served upon the party is lost and there is no alternative for the party to accept the copy to apply for fresh copy in order to be in positions to file the revision petition. The time spent in obtaining the copy would necessarily have to be excluded under section 12(2) of the Limitation Act 1963. So here whatsoever my understanding is this is it has come for this, what is the time limit to be given for the obtaining the certificate under section 12(2). So court has trying to say in such a way, if this person is even lost this copy and other incident, then matter could be different. But if this apply for the certificate copy and it is continuing, then there should not be any limitation about it, but it will be excluded. What's my understanding is this. So this in my case also I have applied for certificate copy and this is the same. So another aspect of matters in the criminal matters decided by this full courts of the Guwahati High Court in that time I was there. This one 2002 volume 2
Yes.
Guwahati Law Report 164. So this matters elusive. This is a lengthy general. So I'll be referring this which is referred, and then I think it will be paragraph 12 elusive. Yes,
12.
Paragraph 12, because there are so many references given order and rules. But I'm coming to this only for condemnation delay only. So I think paragraph 12 will be. So you will see, I'm not coming to the discussion. Already discussion is there. This decree, even the orders, all matters has been discussed, and after this it is come to the conclusion. So I'm coming to the conclusion. In view of our aforesaid discussions, our answer to the question posed in the opening paragraph of this judgment is that the limitation for filing of appeal would start running from the date of the judgment and not from the date of decree. The date of decree would be deemed to be the date of the judgment. However, if an application is made for obtaining the certified copy of the judgment and decree within the period of limitation, the period spent in drawing up the decree as well as the time spent on obtaining the copy of the decree would be excluded. So here in this case, you will see first of all, the person has applied for the certificate of the order, judgment, and subsequently decree has come up, and then it was continuing. So in this case, it is decided if the person is applied for the certificate copy for the judgment and decree passed later on, and it will continue if this application for the certificate copy is filed within the limitation. So out of this logic, out of these orders, whatever I got, so I find that if the petitioners come for this consideration for delay obtaining the certificate copy, then parties should approach within the time of period of limitation.
Yes.
Then it will continue. If it is comes later on, then it will not be counted. So this is my humble understanding, you see. So based this all this judgment and considering the application filed by petitioner, you see, my petition was within the time, and I filed this petition, this even review petition within the time. But on the process of this filing this petition, though it is delay, but it is within the period of limitation, as because I approached before this court in time, and I obtained the certificate copy, and then approached before this honorable court. And this delay, whatever I mentioned in this my petition, it was not triggered, but still I have given, and I pray before this honorable court to consider this. Presenting the petition before this honorable, there is little bit delay, as I considered may be controlled. This is my submission.
Lordship, last occasion, Lordship also heard the matter at length about the delay. Kindly turn to their miss petition 7 of 2025, Lordship.
Yes.
This miss case is offshoot of main case, that is the revision petition.
Yes.
In this revision miss petition, kindly turn to first page, Lordship.
Yes.
We are not objecting for 18 days delay. It is more than about 6 years delay. Because in an application under Section 5 of the Limitation Act for condonation of delay of 18 days in filing civil revision petition against the order dated 9/12/2024 in Mirja case number 29 SH of 2024 for review of the order dated 12/7/2019 in implement substitution application number so and so passed by the reference court. And second, page 3, paragraph 2.
Yes.
The humble petitioner is filing the civil revision application under section 115 CPC for cancelling and or quashing of the order dated 9/12/2024, Mirja case number 29 SH of 2024, and order dated 12/7/2019 in implement substitution application number 62115 dated 23/17 passed by the reference court in custody in the guise of that 9/12/2024. He is challenging the order dated to 12/7/19. Both the order he is challenging in the writ petition, and he has also wanted to only making then submission that there is only 18 days delay for filing of the limitation from the passing of the order in review petition. But he is challenging in the revision petition both the orders, substitution petitions, rejection order, as well as the review petition. The learned court below rightly dismissed the review petition, as the review petition was filed after 210 days of delay without filing limitation petition before the court. That is why on 9/12/2020 case was dismissed without going to merit of the case. Now how can his court, and in that case also the case was pending before the learned Special Judicial Officer Shillong Lordship, that is LA4 of 2024. That was already disposed of. Then mother already died, and now he wanted to survive the son from the womb. That case also disposed of. How he will get the relief in this case now? In his own petition, revision petition, he has challenged both the order. And I have in my evidence in opposition, I have specifically stated about that. And last occasion, Lordship also had my affidavit in opposition. I have stated about how they I am not objecting for 18 days delay, but I am objecting that 5 years, 9 months, 19 days of delay.
Exactly. According to the petitioner, there's only a delay of 18 days.
Yes, Lordship.
But according to you, the delay is not 18 days, but 5 years.
5 years, 9 months, 19 days. Because he had challenged both the orders. Substitution or petition, rejection of substitution petition, as well as this rejection of the review petition order. That is why I have filed the affidavit in opposition. Otherwise, I cannot file an affidavit, because on section 12, he will get a limitation that for obtaining certified copy. And he has stated about one of the party died, but he has not submitted any death certificate along with his petition. That is, apart from that, he has challenged the order dated 12/7/2019 in this case. Then how he can challenge? And that case was, the review petition was dismissed on for barred by limitation. When it is barred by under article under section 3 of the Limitation Act, Lordship also right last occasion also I read the limitation that kindly see, Lordship, the learned court below rightly rejected order, and I have submitted on one judgment in this point also. Bar of limitation.
Section
3 of the Limitation Act, Lordship.
Yes.
Subject to the provisions of contained in the section 4 to 24 inclusive, every suit instituted, appeal preferred, and application made after the prescribed period shall be dismissed, although limitation has not been set up and defense.
Yes.
If I will not set up any defense, then also it is the duty of the court to see that whether it is filed in limitation period or not.
Yes.
He has filed a review petition without condoning the delay.
Yes.
That is my submission before this honorable court. This court cannot go beyond that limitation period, because the that review petition was not supported it with the condonation petition. That is why the honorable learned court below rightly rejected the petition without making any deciding the case on merit. Now he has wanted to, in the guise of that 9/12/2024, he wanted to survive that case of 12, which was rejected on 12/7/2019, Lordship. That is my humble scenario, and kindly go through my additional affidavit, which I have already submitted before the, and I have also read last occasion every point regarding that his petition. And his honorable, my learned friend had cited some of the documents that is relating to the other, not applicable in my case, Lordship. It is obtaining certified copy of how the limitation will counted. That is the judgment. It is not related to my case. I have submitted that judgment. It is specifically mentioned about that delay. Last occasion, Lordship, I have. That is as R. Nagaraj did to LR and others, Rajimuni and others. In 2025, 2025, one Supreme Court, SC C4 623. That is running.
SEC?
Yes, Lordship.
6 to?
Lordship, I had noted.
625.
Page 623, Lordship.
Yes. 623 or 625? What is the case?
2025 1 SCC.
Yes.
623.
623. What is name?
Nagaraj, R. Nagaraj.
Okay.
Through LR, Lordship. Got it, Lordship.
Yes.
I am reading last part because last Stokajan I have read every paragraph, Lordship. Last paragraph, page 16.
Yes.
Page 16. Therefore, we are of the view that High Court was not justified in remanding the matter to the trial court for the fresh trial solely with respect to the issue of limitation, and that to the court below have rightly held that the suit was barred by limitation and respondent number 1 are not entitled to any relief. Last paragraph, this is one. And in the head note, it is mentioned that, Lordship, C, in column C, Lordship, Limitation Act, section 3.
That note is not to be considered.
Yes, not to be considered. After limitation period. This is my case, Lordship. And moreover, that main case that is pending before the learned court below, that was disposed of. And the reference was made between my client and one Ojendranath Kharsandi. They wanted to substitute in the case. That was dismissed. Subsequently, they filed review petition. That was without filing any limitation petition after 210 days. That is why learned court below dismissed the case. Now that case, the learned court on 21/8/2025, Lordship, that the matter was disposed, citing that there is no dispute between the parties because opposite party, Ojendranath Kharsandi, has not appeared before the court, and there is no existence of Ojendranath Kharsandi for referring the matter to before the learned special judge. Now what remains, Lordship? This is all our offshoot of main case.
Okay.
I am not going to dilute everything, Lordship, to spend the time, honorable court time. Kindly go through my affidavit in opposition, Lordship. I have stated everything.
Okay.
Go on the side.
Make this, Lordship. Lordship, I endorse the submissions made by my senior. Moreover, my lord, when we filed the missed case for condemnation, my lord, they had merged both the orders, my lord. So what happened, my lord, in this review application, my lord? So when they had filed the review petition, my lord,
for review of the order dated 12/7/2019, my lord. It was barred by limitations, my lord, because as per Article 125 of the Limitation Act, my lord, is they can file the review within 30 days, my lord. So there has been a long delay, my lord. That's my limited submissions, my lord.
Your Lordship, here my point is there, Your Lordship. I am limited to this extent of this 9/12/2024 order passed by the special judge, not just 17/9/2015 or whatsoever. Because I prefer this review petition against the order passed by the special judge Shillong in 9/12/2024. Not for the others, but I have given the reference to this. This is offshoot of this case. This is the matters. But I am only on the basis of it. This my petition is strict on the order passed by the special judicial officers on 9/12/2024. Not others, Your Lordship. I make this clear, Your Lordship. Even from the beginning, I should make this clear. Because if this order now come up, then I came to the merit of these matters, and then I can come to this matters of the merit as they are saying, whether this petition was all right, whether substitution petition and amendment of the petition has come in rightly or wrongly. You will see, if I come these matters at the moment, it is not the time. I'll call for the record about the matters, you will see. After calling for the report, it will be clear, Your Lordship. And if I go, even as because they are insisting the matters again and again, if I can come to this merit of the matters after calling for the record, I can satisfy the court how I came to this before the court as a petitioner, how I filed the petition, why I have petitioned these matters, subsequently amendment or this substitution, how it has come up, and when this order of this my applications was rejected, whether this petition was rejected was correct. These matters I can come if this record call for, because it is not before this.
Please, Your Lordship.
Just 1 minute. Just here I have just legal points. Legal points only. I am not arguing on the matters. I am giving the legal points. So these matters I have given the judgment, particularly for the first two numbers, you will see, regarding the matters. The merit of the case, as saying, I will be giving the opportunity to hear the matters in the merit of the case. I will satisfy before this court that court of the first instance, the special judicial officers, when he was passed the order, rejected my petition, totally wrong and without having any authority and without following the due process as ancient in the provision of CPC. First of all, my question will come up in such decision if it is honorable court this record. First of all, my question will be coming up. You will see, as the court can reject the petition if out of 5 petitioner, 1 petitioner filed the affidavit. Is it acceptable or not? So this main petition was filed. You will see some extent, if the records come, then it will be. First petition was filed.
Anyway,
So this will be the merit of the case. So if you go to this cat on this aspect of the matters, then this petition filed, this limitation was required. It was also not required. So let us have only the matter, this whatsoever come, then call for the record. And if after this, after calling for the record, you will see, if this court filed this, now I am not having merit of the case, then all right.
Okay.
But I am only the on I am not verse 17/9/2019 or whatsoever they are saying. I am only this point. Special judicial passed the order 9/12, only strict on this.
He is strict on this point, but in the affidavit, his revision petition, he has cited both the order.
But I have given the reference of it.
What is reference? It is in for setting aside.
So I will be insisting on this matter. If they file that, you will see that I am not insisting this all the orders.
How it is?
I am not insisting for this all the orders. I am strict on the order.
And my lord, one more fact, my lord, if I may submit, my lord. My lord, when they had filed the review petition, my lord, they did not file an application for condonation, my lord. And for that purpose, my lord, it was rejected.
Anyway, that is a merit of that review. So I've heard the parties. I'll process the orders. Orders reserved. Heard the parties. I heard land counsel for the parties. Order reserved.
Any mention?
May we please, Your Lordship? Your Lordship, I beg to make a mention for item number 3, Your Lordship.
Lordship, item number 3, my Lordship, there is an order dated 26/8/2025 whereby they were submitting that the appellant wanted to engage some other counsel.
Your Lordship. So they're still searching for a new counsel, Your Lordship. So in the meantime, while the case comes up, it's my duty to inform the court, Your Lordship.
On
So,
premier
Lordship, after 3 weeks.
appellant, this is matter to 2 weeks.
Obliged, Your Lordship.
Lordship, I beg to mention item number 4, my lord, on behalf of the state, my lord. We need some more time, my lord.
Who's for the appellant?
Appellant. Number 4.
Lordship, I'm appearing on behalf of Mr. J. Shilai, Lordship.
After 2 weeks, my lord.
On premier by Mr. S.N. Gupta, and an additional PP, seeking accommodation. The same not be objected to by the general counsel for the appellant, Ms. K. Guru. That is adjourned. This is the after 2 weeks.
Much obliged.
Lordship, I also beg to mention item number 5, my lord. Not 5. Item number 7, my lord.
No objection, Your Lordship.
2 weeks, Lordship.
Could you? No, I can do. 2 weeks.
2 weeks, Lordship. Lordship, I have similar prayer for item number 10 as well, my lord.
No objection, Lordship.
2 weeks.
2 weeks, my lord.
Lord, I appear on behalf of the state lordship. Mr. R. Gurung is the leading counsel lordship. He is on leave lordship for item number 5, 6 and 9 lordship. So I pray for 2 weeks time lordship.
Who is there in 5?
If I'm there, Your Lordship, I'm the petitioner, I'm the appellant, and the item.
Your appellant?
Yes, Lordship.
Prayer is made. Mr. S. Sheikh Larat J has prayed for accommodation on the ground that the Larat conducting counsel, Mr. R. Guru, is indisposed. It seems not be objected to by Mr. Larat counsel for the appellant. That is adjourned. This is after 2 weeks. And then next?
6 and 9.
Who's for 6?
We have already informed lordship.
Item number 6.
I'm petitioner.
Any objection?
No objection.
Could you same order?
Lordship.
9.
In addition, item number 9 lordship.
I'm for the opinion, my
You
lord.
have taken the counsel lordship.
Okay.
Could you? So 2 weeks.
Master.
May it please Your Lordship. Your Lordship, I beg to mention item number 8. Your Lordship, I pray that if this matter can come after a week. As we were informed that the convict is not keeping well, Your Lordship, and he wants to undergo a medical surgery in some private hospital.
Who, convict?
Yes, Your Lordship.
Convict is not well.
Yes,
he wants
Your
to go on. He has
for
to.
surgery in some private hospital.
Have
And
you made
we
any?
pray for 1 week.
No, but
Your
have you made any prayer in that regard?
No, Your Lordship.
Anyway, that will not affect the hearing.
No, Your Lordship.
Hearing will be on merits.
Yes, Your Lordship, but
As far as his condition is concerned, he will have to approach the, the prison authorities, and they will pass his orders, or he may have to approach his court. See, that's.
Yes, Your
But
Lordship.
that will not affect the hearing. On
Actually, we have filed one affidavit to bring on records today morning, Your Lordship, for bringing on records the medical records of the convict, Your Lordship.
Your Lordship, they had filed the affidavit without taking leave from this court. Your Lordship, we received the copy today. So.
Because we were informed that he needs a surgery, Your Lordship, and I pray that this matter may come up in a week, Your Lordship.
You see what is the proper approach
Yes, Your Lordship.
on premier the appellant. List this matter up to one week.
1 week, Your Lordship.
Much obliged, Lordship.
Highly obliged.
From supplementary list, item number 1.
Wait, please, Lords.
Yes.
Well, this is a appeal from a judgment and order dated 9/9/2025, which concerns the transfer of the appellant before my lords.
Yes.
Now, my lords, the limited issue involved here is, my lords, whether the transfer order was punitive. And it is the case of the petitioner, my lords, that the transfer order was punitive.
Yes.
Now, what I had prayed before my lords, this matter, the same matter which had come up before my lords on Monday last. I had pointed out, my lords, that this matter can be admitted, and a date be fixed for final hearing of the matter, my lords, on an early date. That's my limited prayer.
But I am appealing for
This
the
matter,
lordships can hear.
appeal has not been admitted.
No, my lords, it's just been filed. The matter had come up on Monday. I had prayed my lords may admit the appeal and the matter can be heard, my lords.
The lordships can hear me, my lord.
Yes. So
I am appealing for the opponent. But here what happened, my lord, the appellant is a commandant in CRPF, my lord, posted at Shillong. Now what happened, my lord, the headquarters received information that the commandant and the second in command, they have a personal conflict among themselves, my lord, and that was affecting the morale of the morale as well as the functioning of the unit. And so that is why he was transferred to Jodhpur, my lord. The relieving order has been issued, and someone else has been posted in his place, my lord. Now he approached the learned single judge, taking certain grounds. The learned single judge was pleased to dismiss the writ petition, my lord, with the conclusion that there is nothing, and the transfer is an exigency of service. Now against that, they have come on appeal before the lordship, my lord. Now, my lord, the only thing is, my lord, relieving order has already been issued. I have no objection if the matter is taken up, because I think I should be there in next week, my lord. So the matter
It's only considering that my friend is not here, my lords, I made this prayer.
So you suggest a date then?
Next Monday or Tuesday, my lords, if my lords can accommodate us.
Well, Monday, I don't know, my lord. If it's kept on Tuesday or Wednesday, my lord, I most probably I'll be able to come, my lord. Tuesday or Wednesday.
No, Wednesday then. We're sitting Wednesday. Monday, Wednesday and Friday. That was Wednesday, no? Friday. So we'll take it up on Wednesday then.
Well, let the appeal be formally admitted, my lords, and the matter can be fixed for hearing on Wednesday.
Formal admission may be taken, interpreted in a different way, my lord.
Anyway,
there's no interpretation, my lords. As a matter of fact, I have filed an affidavit bringing on record.
Anyway, fine.
The relieving order
We'll admit your appeal.
Well, if the appeal is to be heard, it will have to be admitted. Let it be admitted.
Any paperwork required?
No, paperwork is not necessary, my lords. We have everything on record.
Okay. Heard Mr. K. Paul and Senior Counsel, along with Mr. Estapa, for the appellant. It is this submission of the learned Senior Counsel that, being aggrieved and dissatisfied by the order dated 9/9/2025, passed by the learned single judge in UPC number 379 of 2025, the appellant has approached this court with this instant appeal. At this juncture, the learned senior counsel has submitted that, has made a prayer that the appeal be admitted and the same be heard on merits. Dr. N. Musika, Leonard DSGI, appearing along with Ms. K. Gurung, appearing for all the respondents. You appearing for all the respondents has accepted notice on behalf of such respondents. Accordingly, no formal notice is required to be issued herein. There is also no objection to the appeal being admitted. Accordingly, on perusal of the impugned judgment and order, we are convinced that the appeal merits admission. Same is done so here accordingly. As prayed for by the parties, this is appeal for hearing on next date is
24th.
24th September.
24th.
Next Wednesday.
Next Wednesday. Have a blessing.
Item number 2.
Right.
May it please your lordship. Your lordship, in this matter, I am a legal aid counsel for the appellant, my lord. And my lord, the petitioner herein, my lord, is assailing the impugned judgment dated 28/03/2024, my lord. Order, that is an order on sentence and judgment, my lord, wherein the appellant has been convicted for life imprisonment in a matter of 302, my lord.
302.
Yes, my lord, and it has been convicted by the judge of West Jaintia Hills, Joai, my lord. So, my lord, my lord, in the application of condonation of delay, my lord, it has been delay of 476 days, my lord, because the appellant is not well versed of his legal rights to approach, my lord, to file the criminal appeal, my lord. So, hence, on that reason, my lord, there has been a delay.
Yes, who's appeal?
May it please your lordship. Lordship, as in other appeals, I've always pointed out to the concerned court's lordship that the reasons shown is just one line, and it always pleads ignorance of filing of appeal. Lordship, we are sitting on a delay of more than nearly 500 days, lordship. And your lordship, when the judgment is passed in the open court, the presiding officer, the judge concerned, the trial court judge, lordship, they always inform the convicted person of their right to appeal, lordship. And lordship, in this case, it's not a matter that has been handled by a legal aid counsel. This was by a private counsel, lordship. So, my lordship, I am raising objections. As every time, lordship, I'm raising objections. Because one line explanation for 476 days, lordship. True, it's a criminal case, lordship. True that the Supreme Court has observed otherwise. But, my lord, one line explanation, lordship.
What is the antecedent of the appellant?
My lord,
is he a villager? Is he?
Yes, my lord, he is a villager. He is a truck driver, my lord. He is a villager. So, my lord, he is not much aware of the rights that he was, because, my lord, when I was endorsed with this matter initially, my lord, I had received the copies and everything, my lord. It wasn't clear also, and then I revert back to the committee, and then after that, my lord, I got the signatures and everything, and still I have asked him, my lord, the reason of why he did not approach as per the appropriate time, the time period limitation, my lord. But he said that, my lord, since the jail is also from West Jaintia Hills, and my lord, there was very complicated matter for him, my lord. And finally, my lord, so, my lord, I pray, my lord, to at least condone the delay of 476 days, my lord, since, my lord, it is a legal aid matter, and moreover, my lord, the appellant herein is not much aware, and he's not much well sound of the law, my lord.
I'm raising my objections, lordship, as I have raised on other matters.
Heard, Miss Legal Aid Counsel, who has submitted that the appellant actually, when you prefer this kind of application,
yes, my lord,
should not be appellant, should be applicant.
Yes, my lord. Yes.
An application is filed. Appellant means, concerning the appeal.
Yes, my lord.
That is a mistake everyone makes. I don't know.
Well, I'll keep that in mind.
I under bracket 6 applicant has been convicted by the learned sessions judge in sessions case number 53 2014, sessions judge West Gentile Hills District Johio, wherein by judgment dated 28/3/2024 and related sentence dated 3/4/2024, he was made to undergo life imprisonment for an offence under section 3, made to undergo imprisonment in terms of section 302 CRPC, IPC. However, the applicant has now come before this court with the related appeal and also with this instant application seeking condonation of delay of 476 days in filing the said appeal. Next, the learned NSC has submitted that the reasons for the delay in filing the appeal is that the appellant is a truck driver who is not so well versed in the law or is not made aware of his right to file appeal, and as such, for such ignorance, the delay has accrued. It is prayed that this application will be allowed and the delay in filing the said appeal be condoned. Ms. Per contra, Ms. Gisela, additional senior J, appearing on behalf of the state respondent, has opposed the prayer made in this application on the ground that when the judgment of conviction was passed by the learned trial court, it was done so in open court in the presence of the accused oblique applicant, and he was also told or informed of his right to file appeal. Moreover, he was duly represented by a counsel. As such, there is no question of his ignorance of the procedure of law as far as filing of the appeal is concerned. It is prayed that this petition will be dismissed. We have considered the submission and contention made by the learned counsel for the parties. We are also conscious of the fact that the related appeal has been filed after a delay of 476 days, which by itself constitute inordinate delay. However, taking into account the fact that it is not expected for the applicant oblique accused to understand the nitty-gritty of the legal process as to his right for filing appeal, and more so the fact that he has been convicted for commission of very serious offence of murder. Accordingly, in our opinion, in the interest of justice, the applicant or the accused oblique convict deserves the right to be heard. Therefore, this application is hereby allowed. The delay in filing the related appeal is of the delay of 76 days in filing the related appeal is hereby condoned. Registry is directed to digest the appeal and list the same for admission after 1 week. Petition disposal.
Apply, Lordship.
Item number 3.
Lordship, conviction under section 4 of the
This is a review.
It is seeking some clarification, my lord. It's not a review. Anyway, my lord, since it is not there, it may be coming up on Tuesday or Wednesday, my lord. Subject to lordship convenience.
What is the difference between clarification and review?
My lord, my lord, here review is, my lord, there is some apparent.
When you clarify an order, means you are effectively reviewing the original order.
What happened, my lord? I'm not seeking for review. What happened? Lordship has held that the technical eligibility of the applicant here cannot be revisited by the authorities. Now, what they have done, the director issued another letter, refused to take my EMD on record, with the impression that, my lord, this honorable court allow him to do that. My lord. According to me, that amounts to revisiting the technical eligibility which was upheld by my lord. So some clarification on to that extent. Otherwise, the action of the respondent amounts to contempt of court, violation of law. But I don't want to do that. But therefore, we filed this as simple application to seek some clarification. It may be listed on a Wednesday. Since the application is
correspondent 4 here, madam.
Yes. Anyway,
I was also trying the matter will take up on Wednesday, madam.
Wednesday.
Wednesday.
When the matter came up for consideration, Mr. J. Leonard J has sought for accommodation on the ground that Mr. Indishwar Leonard AAG, who is handling the matter, who is the conducting counsel on behalf of the respondent number 1, 2, and 3 respectively, is indisposed on grounds of personal difficulty. Leonard counsel for the applicant, Leonard senior counsel for the applicant, Mr. Chen Saveso, has no objection to the prayer made for accommodation as far as the day's proceeding is concerned. Accordingly, as prayed for, this matter on 24th.
Evening, right?
This item number 1.
We'll go on today.
Wait, please, Your Lordship. Lordship, here, Your Lordship, we have preferred an appeal, Your Lordship. This matter is pertaining to last leg posting, Your Lordship. Lordship, here, Your Lordship, we have already filed our affidavit of service of Lordship, but then the respondent is not here, Your Lordship.
So, notice has been affected?
Has been affected, Your Lordship. We have duly filed the affidavit of service on 4th of September as well, Your Lordship.
What is your case here?
Lordship, this matter is pertaining to last leg posting, Your Lordship, wherein the respondent, Your Lordship, is an employee in Assam Rifle, Lordship, and he's retiring in the month of May 2026, that is next year, Lordship. And as such, he's having less than a year, Lordship, in his service, Lordship. And at this stage, Lordship, giving him his last leg posting will entail unnecessary transportation costs for us, Your Lordship.
Oh, and this is an appeal?
Yes, Your Lordship.
Against which order?
Your Lordship.
What's the impugn order?
Impugn order is at page 76, Lordship. Lordship, if I may draw Lordship's attention to paragraph 5, Your Lordship. That will be at page 79.
He is serving where?
Your Lordship, he is serving Assam Rifle, Lordship.
Here in Shillong?
Lordship, at present, Lordship, I'm not aware, Lordship, at present. Lordship, Kakjin, Your Lordship, is it Manipur? Kakjin, Manipur, Your Lordship.
Oh. September. Oh, till 26. So, by the impugned order passed by the learned single judge,
Yes, Your Lordship.
his transfer is to be effected.
No, Your Lordship, his transfer has not been effected, Your
No,
Lordship.
he is to be effected.
Yes, Your
But
Lordship.
there is a stay there.
Yes, Your Lordship. Your Lordship, if I may draw Your Lordship's attention to page 52, Your Lordship. Para 52, last leg posting, Your Lordship.
No, we will not go into the merits of the matter. First, we have to ensure that he appears.
Yes, Your Lordship.
When the respondent is going to retire?
Next year, Lordship, in the month of May 2026.
Yeah. Yes, Miss Miss Kigun, the counsel for the appellant has submitted that the notice issued upon the respondent has been duly effected and an affidavit of service dated 4/9/2025 has been filed for this court, indicating as such. However, the respondent has not yet appeared before this court. Even today, when the matter is called up for ends of justice, we allow the respondent to make his appearance for this court on the next date fix. This is matter to 2 weeks.
Much.
Next to with reference to our order dated 38/2025, wherein this court has directed for stay of the impugned order till 26 September 2025, or until further orders, by this instant order, by today's order, we extend the operation of the stay of the impure order till the next returnable date.
This was for you to point out. You did not point out. Was it not?
Yes, Your Lordship.
It stays on your. Anyway.
Much obliged, Lordship.
Item number 2.
This is application for condonation of delay, which is raised today. But I'm given to understand that Mr. Shulai is not here.
Your Lordship, we've already filed our objection to the misapplication for condonation. However, Your Lordship, today Mr. The learned advocate, additional advocate general is not available. So I'm seeking for some accommodation. It can be heard maybe next week, Your Lordship.
No problem.
You've received the.
Yes, I have received. The only exception they have taken is on the length of the delay. There's a delay of about 1,154 days in preparing the writ appeal.
Mr. heard Mr. K.C. Gautam, counsel for the applicant, who has submitted that the objection to the application filed under Section 5 of the Limitation Act has been objected to by the state respondent. Copy of such objection have been received by the applicant. It is prayed that this matter may be taken up for hearing on the next date. Accordingly, as prayed for, this is matter after 1 week.
Much obliged, Lordship.
Item number 11.
My Lord,
Please, Your Lordships. My Lords, I'm praying this matter may come up anytime next week. My Lords, I'm praying for some accommodation today.
Why have you not sought for accommodation during mentioned hour?
Lordships,
You have made Mr. Sangriso waited for so long.
Lordships, I do apologize, Lordships.
Tomorrow is holiday, he could have gone.
Lordships, a short accommodation, Lordship.
On payment by Mr. Counsel for the appellant seeking accommodation, matters adjourned. This is the same after 1 week.
Highly obliged, Lordships.